Now under the introduction, we will also understand the two more topics. The topic number 1 here is the lifting of a corporate veil. Corporate veil means what? It means separate legal entity. Now we are very well aware that the company is a separate legal entity. In the good language, it is known as a corporate veil, right? Lifting of a corporate veil means what? That means removing or disregarding the separate legal entity. My dear friends, in a certain situation, the benefit of the separate legal entity is not given, and those promoters, directors, or the person who are behind the company and has obtained the benefit in the name of a company are liable for the purpose of an offense. A very simple company format of a business is allowed for the purpose of genuine business, legal business, for a honest mean. If any person do the business which is illegal, which is fraudulent, which is improper in the name of a company, and then after on being arrested or on being caught, if he argue that it is not a me, it is a company which was doing the business, so I am not responsible, company is responsible because there is a separate legal entity. Now this kind of a benefit is not allowed to anyone, and therefore there is a possibility of removing, disregarding or lifting of a corporate veil. That means in a certain situation, the company and its directors are considered as the same and one, and for the any kind of a default committed by the company, their directors are regarded as a default, right? And they are liable. Now this lifting of a corporate veil is classified into the two categories. Number 1, lifting of a corporate veil under the statutory recognition. Statutory means under the Act. So Companies Act 2013 itself provide the certain provision where there is a possibility of lifting of a corporate veil. Which are those provisions? Number 1, when the company is incorporated by the subscriber, by the promoter, by any person, by providing the wrong or a false information, right? So then that person can be held liable, and company is not liable for this default, right? Number 2, when any person who were responsible for fraudulent conduct of a business during the winding up, any time during the winding up, can be personally liable, right? Third, if the directors fail to return the application money within a specified period of time, in the share capital or later part, you will learn that the interest of a certain percentage is payable if there is a delay in refund of application money. The same you must have learned under the accounts. So whenever there is no refund of application money, this interest is payable by the directors, because the directors of a company were responsible to repay the money. No doubt the money was collected in the name of a company. Number 4, if the prospectus of a company contain any false statement or any misleading statement, then the person who are promoter, who are directors, who are named as a director are liable for this wrong statement in the prospectus. No doubt the prospectus is prepared in the name of a company, but question here is that who prepared the prospectus? Directors of a company. So directors of a company are held liable. They cannot take the benefit of a separate legal entity. Now the next part of a discussion under the lifting of a corporate veil is judicial interpretation. What is the meaning of the word judicial interpretation? Now, this kind of points are not written or provided under the Act. But over a period of a time, various honorable court has provided this kind of a judgment, and in a future, if the case is based upon the similar fact, the same kind of a rule is applied. That is what known as a judicial interpretation, based upon the explanation provided by the court. If the company format is used for the purpose of any fraud or improper conduct, then there is a possibility of a lifting of a corporate veil, right? Say for example, in the landmark judgment of a Jones versus Lipmans, where the company was formed, right, just to avoid the land transfer. Say for example, A was the owner of a land. He entered into the contract or an agreement to sell the land to somebody. Now, to avoid this transfer, he formed the company and he transferred the land to the company. Now, on being asked, the A said that now the land belongs to the company and I am a separate legal entity. Company is a separate legal entity. So, now I am not supposed to transfer the land or give the possession of a land. So now this was a fraud purpose. What was the purpose of the company, formation of a company? To fraudulently transfer the land. So this fraudulent activity for which there is a lifting of a corporate veil is possible. Here, in this case, the court has provided the judgment that the company should surrender the land to its original or first purchaser, right? By using the separate legal entity, company cannot create the fraud because the company format is utilized for the honest purpose of the business. Number two, when the conduct is in a conflict with the public policy, when any activity of the company is against the public policy, in a simple language, would like to say against the public policy. Now, I don't need to explain you what is against the public policy because you learn it, right? Remember, the company format of a business is not allowed for the purpose of creating the harm to the public. So, if any company is doing the business, conduct the activity which is against the public policy, which is not a beneficial to the public, there is always a possibility of lifting the corporate veil to find out in the name of a company who are getting the benefit, right? Say for example, A start the company A Limited and collect the money in the name of A Limited, right? Now, once a public or a person pay the money, deposit the money with the A Limited, A take all the money and run away. Now, the company format of business was made for a genuine business. A prepared a scheme of fraudulent to deceive or cheat the public by collecting the deposit in the name of a company. So that was against the public interest, and here the A cannot say that the deposit was collected in the name of A. A will be responsible for a deposit collected by the A Limited, applying the rule of a separate legal entity. Sometimes the lifting of a corporate veil is also applied to find out who is really the owner or whether the company is having an enemy character. In fact, the company is not a friend or an enemy. But in this case, some German citizen started the company in a UK. At that time, it is a very old case. At that time, to start a company in a UK by the German was prohibited. So this German approached their friends who are basically belonging to the UK. So they were having a UK citizenship. German asked their friend to start the company in the UK, right? And once a company was started, was doing the good business, almost 6 to 8 months thereafter, the ownership, that means the directorship, was transferred from a UK citizen to German, right? Now one day, this company in the UK filed a case to recover the money from the one of the agent. The court has held that any agreement with the enemy is not valid. Now, in fact, the agreement was between the German and the agent through the company. Now, German was considered as an enemy by the UK at that time based upon the World War, right? And there was a rule at that time that no German people can do the business in a UK, right? Now, it was held by the court that this agreement is agreement with the enemy and therefore it is a void. This company, even though it is established in the UK, cannot recover the money from the agent. So it is based upon the separate legal entity principle disregardment. Here the separate legal entity principle was not considered, right? Next, the separate legal entity principle, that means the lifting of a corporate veil, is a possible whenever the company is formed just to avoid the tax liability. And in the language of a taxation, there is a clubbing of an income, right? The lifting of a corporate veil is a possible when the company formed the subsidiary company and subsidiary company is not doing any other activity. Say for example, A Limited is a holding company and it has started the B Limited. In fact, the B Limited, which is a holding company of A Limited, is not doing any genuine business. But this company was started to avoid the tax or to reduce the tax, to generate the wrong expenses. For an example, what an income tax can do, they can treat both the company as the same and one and club the income, right? So what we will say, lifting of a corporate veil. Whenever any company is started to avoid the welfare legislation means labor legislation, then there is a lifting of a corporate veil. Say for example, some company are required to pay the gratuity, contribute to the gratuity fund. Now if the company fail to contribute to the gratuity fund, who will be liable? Its director will be liable. Why? Because it was a responsibility of a directors to contribute to the fund. Here, the directors cannot argue that it was a fault by the company because the company is an artificial person. Here, the principle of separate legal entity will not be applicable. And whenever the company undertake any activity which is a criminal liability, then company is not liable, but the person who has undertaken this activity will be personally liable. Because the company do not have a mind. And if the company do not have a mind, how we can understand, how we can take it as a criminal liability? Because to commit a crime, you require the guilty mind. You require the guilty mind. As a company do not have a mind, there is no question of a guilty mind. So company cannot commit a crime. If the crime is committed, it should have been by the director, and the directors will be personally liable, considering the principle of a lifting of a corporate veil, right? Let us move to the next point. And it is the illegal association. Section 464 of the Companies Act contains the provision with regard to the illegal association, right? Now, first of all, let us understand the meaning of the word illegal association. Illegal association means any company, any partnership firm, any association having more than 100 members and not registered under the Companies Act or other act, thereupon it becomes the illegal association. So there are the 2 points to be considered for the purpose of an illegal association. Number 1, the member of this company, firm, association should be more than 100, and it is not registered under the Companies Act or under any other act, right? If it is registered under any other act, it will not be regarded as an illegal association. Now, certain category of the business units are exempted from the illegal association. For example, HUF. If Hindu undivided family, irrespective of the number of the members, say for example, if one family is having 200 members, and if they are having a joint business, they can do or undertake the business without registration, and even though it will not be regarded as an illegal association. Number 2, any trust or NGO, that is a non-government organization, which is made for the purpose of a charity, because they are not having the objective of making a profit. Say for example, if 300 people gathered and undertake the charitable activity, they are not required to be registered, and even though they will not be regarded as an illegal association. What will be the effect of an illegal association? Remember, the first and the foremost effect is that every member of an illegal association will be or shall be punishable with the punishment of 1 lakh rupees. For any contract or agreement, the members of an illegal association are personally liable. So if any contract is entered into, the members of the illegal association will be personally liable. Illegal association or its member cannot sue or cannot be wound up. It cannot sue because it does not have any legal existence. Right? And as it is not registered with any authority, there is no question of winding up. Right? However, if the illegal association has undertaken the business and incurred the profit, his profit or its profit is subject to the tax. And the most important point is that if there is a subsequent reduction in the number of members, say for example, there is one association with 150 people not registered and 60 of them died in one terrorist attack. Now the number of remaining member is 90, well within the limit. Now on the reduction of the number of members, the illegal association will not be converted into the legal one, because once illegal, always illegal. Only remedy is to close down the business. You will note down the point. Thank you.